A few years later, in 1925, the court handed down its decision in Gitlow versus New York. Gitlow, a socialist, was arrested for distributing copies of a left-wing manifesto that called for the establishment of socialism through strikes and class action of any form. Gitlow was convicted under a state criminal anarchy law, which punished advocating the overthrow of the government by force. At his trial, Gitlow argued that since there was no resulting action flowing from the manifesto's publication, the statute had penalized speech having no propensity to incitement of concrete action. The New York courts had decided that anyone who advocated the doctrine of violent revolution violated the law. Was the New York law punishing the advocacy of overthrowing the government an unconstitutional violation of the free speech clause of the First Amendment? The Supreme Court held that a state may prohibit both speech and publication if they have a tendency to result in a dangerous action to public security, even though no such utterances create a clear and present danger. The rationale of the majority has sometimes been called the bad tendency test. The legislature may decide that speech may be prohibited even when it poses a threat to government's ability to maintain order at some remote point in time. Those legislative decisions will be upheld if not unreasonable, and the defendant will be punished even if his or her speech created no grave and immediate threat at all. Thus, the court gave government still greater authority to regulate speech than it had in the Schick case. As a footnote, we should add that the Gitlow decision is significant also because the court addressed the question of whether the First Amendment applies to the states. The court held that it did, by virtue of the liberty protected by the Due Process Clause of the 14th Amendment. Thus, despite its restrictive interpretation of speech rights, the Gitlow decision marks the advent of the doctrine of selective incorporation.